Shashi Tharoor. Already I heard. Shashi Tharoor.
Thank you, Mr. Deputy Chairman, for the opportunity to initiate the debate on the Negotiable Instruments Amendment Bill 2017. It's obviously very important legislation, as the Honourable Minister has just explained, to address some of the existing concerns around cheque payments in our country. And for that very reason, the Indian National Congress, which has worked tirelessly to represent the voices of small, medium, and even, when appropriate, big industry, does not object to it on principle. But the question I have to ask the Minister is this version of the bill the best that we can do for this country, at a time when the strains and stresses on the economy have reached an all-time high due to the twin disasters of demonetisation, which was a bad idea implemented badly, and the botched rollout of GST, which was a good idea implemented badly. Now, in these circumstances, unfortunately, the answer is no, and I will try and explain what my concerns are. They differ slightly from my honourable neighbour, Mr. Sampath, but on the constitutionality, I'm sure he will address the matter. My concern is about the practicality. Now, what is the purpose of the bill? The purpose of the bill is to deal with cheque bouncing, ensure that we have, therefore, one more contribution to the ease of doing business, the annual set of metrics on commercial activity undertaken by the World Bank, which our Prime Minister has announced as a major target for this country. As you know, the Prime Minister said that he wanted to put India in the first 50 of the countries in the ease of business ranking, ease of doing business ranking, and that's a laudable, if challenging, objective, which will certainly be undermined if we don't fix our cheque system. Having said that, we now have the word of the World Bank's own chief economist, Paul Romer, who says there are serious flaws in the methodology employed in worrying about ease of business rankings. So maybe that is not what we should do. We should instead be looking much more at the decent lives of our own citizens and ask ourselves, can we do more? Can the government and this parliament do more to help struggling citizens who are coping with the sort of cheque vapasi that happens? Somebody gives them a cheque that they have no intention of honouring. They then end up with the cheque bouncing, and the innocent citizen is left without recourse under our existing laws. Now, Mr. Chairman, we all know that investment and the inflow of capital into our country are both essential for the development of our nation. We all know that without cheques, you can't have commercial activity. We can talk all we like about a cashless society, but cheques are the first sign of a cashless society before we get into credit and debit cards. In fact, I've looked into this, and it seems that commercial transactions in August 2017 alone, just to take one month, the transactions by cheque were more than 6 lakh crore rupees, which is more than 3 times the amount conducted in debit card transactions or credit card transactions in our country. And as per the Reserve Bank of India's annual report, in the last fiscal year for which we have this report, 2016-17, there were 74 lakh crore rupees in transactions. So the credibility of cheques is not only important for corporate entities, but also for ordinary people when they receive payments such as their salaries in the form of cheques. Now, the existing law, Mr. Chairman, has a swift procedure under Chapter 17 of the Negotiable Instruments Act on cheque bounces. There was an amendment made in 1988, which is Section 138, in order to give credibility to the settlement of liabilities. And then in 2002, the Act was again amended to provide for the summary trial of wrongdoers in such cases. And the idea was, of course, something that I will address later, that is the delays already in the judicial process even then. But unfortunately, despite those 2 amendments, our courts are clogged with innumerable cheque bounce cases, creating tremendous stress on the judiciary and hurting the interests of the aggrieved parties. And unfortunately, the slow pace of deciding these cases, because of the sheer backlog involved, has not only undermined the ease of doing business, it has actually improved the ease of doing cheating in our country. Now, according to the 213th report of the Law Commission of India, there are 38 lakh check dishonor cases pending before our courts in 2008, which constitutes 20% of all the criminal cases in India. I'm not even sure we realize, this House had realized, that 1/5 of all the criminal cases in India actually involve check bouncing. This is a very serious problem, and the bill proposed does not do enough to address it. And I'll explain why. What has been proposed certainly is desirable. It will strengthen the purpose of the existing bill. But though these measures may be necessary, Mr. Minister, they are not sufficient. They are not sufficient to handle the very, very serious dimensions of the problem. For instance, the interim compensation to the complainant can only be ordered by the court after the accused has been brought to the court and pleads his innocence at the stage of framing of charges. Now, what we all know is you can't always bring these chaps to the court. A lot of time is spent even trying to serve a summons to the accused. They don't cooperate, they often abscond, or they evade the arms of the law in a bid to frustrate the entire participation in the trial. There is a flaw that I already mentioned last week in addressing the Fugitive Economic Offenders Bill. It does not provide for trial in his absence. So once the person absconds, you can't try him, there is nothing you can do. It's a very interesting situation. Shakespeare, Cymbeline, there was a famous line of Shakespeare's that said that the comfort of being in jail is that one need not fear paying the tavern bills. In India, it seems to be the opposite, that the absconder need not have any fear about paying his tavern bills because he won't be there for the courts to take action against him. Now, I'd like to draw your attention to two cases, Mr. Chairman. One is Kalai Selvi versus Shiva Subramaniam in your own state, Mr. Chairman, where the accused was convicted of dishonoring a check under the existing law. He filed an appeal. After filing an appeal, he became an absconder. Neither he nor his counsel appeared before the court. So the appellate court directed the lower court to implement the judgment. But then he went to the Madras High Court, which reversed the decision on the grounds that in a criminal case, an ex parte decision cannot be taken because every individual has a right to be fundamentally defended by lawyers. So his not showing up in the court and not being there with his lawyer meant that he could actually escape judgment. Now, if a person willfully avoids a legal process and refuses to appoint a lawyer to represent him, in order to frustrate the proceedings, should the aggrieved party be denied his fundamental rights to comfort? But under our existing law, unfortunately, that is what happened. The Supreme Court actually took note of this decision in another case, Hussain versus Union of India, in which the court observed that denial of timely justice is a violation of human rights and erodes the public's confidence in the administration of justice. The court therefore recommended, because only the government can do it, that the government should introduce an amendment to the Criminal Procedure Code to provide for trial in absentia of absconders. This is something which, for example, the Bangladeshi government did. They also inherited the same Criminal Procedure Code from the British Raj, but they have created their section 339B, in which they have introduced trial by absentia. The Supreme Court, in May of this year, has reiterated this recommendation through an order in the Bachhe Yadav case. Now, if trial in absentia can be allowed, especially for check bounce cases, the delay in the cases can be avoided to a large extent. Now, as I mentioned, I have made the same suggestion with regard to fugitive economic offenders. Once they go off as fugitives, our law seems helpless to deal with them. We need to have the government introduce a trial in absentia provision, and I recommend it very strongly to you. The government, in drafting this bill, also does not appear to have taken account of the best practices from other jurisdictions. In France, for example, a person who defaults on his cheque payments is added to a central register known as the Fichier Central de Chèques, FCC, and he is banned from issuing any cheque for a period of 5 years. You could have put that into the law, you have not done so. This has actually proven to be a very effective deterrent in France. A similar mechanism could easily have been considered in drafting your bill, that if somebody bounces a check, he cannot write another check for 5 years. And there is a central register so his checks will be dishonored. Similarly, in some states in the USA, such as in Arkansas, increased penalties were imposed if there is a second instance of a bounced check after the first conviction. So that again would have been another possibility. If you don't want to ban him for 5 years, give him one more chance, fine, but after the second instance, he should be banned. But we don't have any of these provisions in the bill. That's why I said it's a good bill up to a point, but it's not sufficient. Much more should be added. Now, no matter how many procedures are prescribed through legislation, Mr. Chairman, there is absolutely going to be only a minimal impact of this law unless reforms are undertaken in the very institutions that support our legal system. The Law Commission had, for example, recommended the establishment of fast-track courts for check bounce cases. And the idea was that the adjudication of such cases could be expedited. Now, we often hear of fast-track courts as a term in our country, but the truth is they are not mainly newly established courts. Instead, they are existing courts that are designated as fast-track or special courts in addition to the general matters they are handling. They have the burden of managing some fast-track processes. Very honestly, none of the fast-track courts works as fast as the legislation had intended. So I would have urged the government to include in this bill this recommendation to include fast-track courts exclusively meant to hear check bounce cases, negotiable instruments cases. If you had done this, Mr. Minister, this would go a long way in boosting the faith in our business environment and improving the lives of our people who depend on check transactions. My last point, Mr. Chairman, is the larger question that this entire exercise brings to bear on the state of our judiciary. The government informed this House on the 18th of July that there were 417 vacancies in the higher judiciary and a total of 5,436 vacancies in the lower courts. Now, on current count, we are a country where we have only 16 judges per million head of population, which is the lowest of any major country in the world, the lowest number of judges. It's a disturbing and worrying statistic, and on top of that we have such a large number of vacancies. Our courts lack basic infrastructure and facilities. Our finance minister does not give them adequate budgetary allocations. Even the Supreme Court has said that the lower judiciary is likely to crumble under the twin pressures of the lack of facilities and of judicial officers unless this crisis is addressed immediately. The level of pressure on our judges is enormous. For none other than the then Chief Justice of India, you may remember, Mr. Minister, broke down in front of the Prime Minister and wept in 2016, lamenting the inaction by the government in remedying the problem of not having enough judges in this country. The Prime Minister had said at that time that he would take action. Sad to say, 2 years later, no action has been taken. So as such, no matter how many laws we pass in this House, unless this government shows the will to improve our courts, I am afraid that justice will remain just as elusive as the money that is owed on bounced checks to so many millions in our country. In conclusion, Mr. Chairman, let me say to the government, we are not going to vote against this bill because the only problem with the bill is that it's inadequate. It could have been a much better bill. It could have been a better bill if it had included trial in absentia, fast-track courts, and the other ideas I mentioned in my remarks. If the government wishes to bring those amendments in, we'll be very happy. If not, if the government wants to go ahead with this bill in its present form, I would only recommend and request that it consider seriously bringing in a new amendment that will take into account these approaches, because right now we have a bill that is actually grossly inadequate to the purposes that you are trying to serve through this legislation. With those words, Mr. Chairman, I conclude.